Meanwhile, our reporter Nomawethu Solwandle spoke to attorney William Booth about what has transpired in the last 3 days.
If one goes back to Monday, when the sentencing procedure started, many people kind of expected the judge would walk in to court and just hand down a sentence, but obviously that doesn't happen. She had to listen to evidence in mitigation of sentence because the defense then has to start, unlike with the actual trial where the state presents its evidence first because they've got to prove their case beyond a reasonable doubt. So the defense called a clinical psychologist. Somebody from the Department of Correctional Supervision was called with regard to the issue of correctional supervision as a sentencing option. And then we also had a probation officer. We've also heard cross-examination. The evidence that has been presented by the defense is looking at and trying to focus on a non-jail sentence for Oscar Pistorius. The prosecutor has climbed in a bit, certainly with the last witness, the social worker, and attacked her evidence, saying it's not appropriate, and also with regard to the correctional supervision officer, saying it wasn't an appropriate sentence. Now, the evidence of the correctional supervision officer was that Oscar is a suitable candidate for correctional supervision. That's a sentencing which has house arrest as a component, community service, attending treatment programs, for example, like anger management, which might be applicable in his case, and even having a compensation as part of the sentencing option. We heard yesterday and today the social worker who indicated that the prisons couldn't accommodate Oscar, and I think she was taken to task, possibly correctly so, because I think she should have investigated all of the prisons better than she did. She said she visited one 2 years ago and another one 10 years ago and had heard a lot from other people. So Gerrie Nel said, well, hang on, there are prisons that can make provision for somebody in Oscar's situation. There are many people who are in prison who have similar problems. Many people in prison we know who are seriously ill, and in fact some of them die in prison. But one has to compare case for case and prisoner with prisoner before you make deductions whether Oscar should or shouldn't go into prison.
Just while you on that point, this Oscar trial is a trial that has polarized the country. We see Twitter, Facebook going abuzz with all these witnesses that are being called in by the defense. But what does the law say?
Well, the law says the court must look at 3 factors. That is the personal circumstances of Oscar, and the defense have obviously been focusing on that. They're there to represent Oscar. And they've called witnesses to kind of suggest a sentence of correctional supervision and not to send him to jail. That's why this focus on prisons can't accommodate somebody like Oscar Pistorius. The court has to look at his personal circumstances, the interest of society, that is all of society, not one particular group or not the family of Oscar, but everybody, and then look at the seriousness of the crime. Culpable homicide of the nature of Oscar's incident is very serious. And the judge, during her ruling on the evidence and before she made a finding, indicated that this was an instance of severe negligence, gross negligence. So that makes it very serious. A firearm was involved. The state will be presenting evidence to kind of counter the defense's argument that he shouldn't go to jail. And we've heard a member of the family testifying today, presenting evidence about Reeva and her family. Those are relevant factors, but the court can't say because Reeva's family is grieving, therefore somebody must go to jail. It's got to balance those 3 aspects that I've just mentioned. And then I believe that the state will be calling somebody from Department of Correctional Supervision with regard to what the prisons have. Can they accommodate somebody with the disability of an Oscar Pistorius? So that evidence, I think, will be presented tomorrow.
Also, the trial has dragged on for so long, we sort of forgot some aspects of it. And what was Gerrie Nel actually focused a lot on the cousin today, talking about who Reeva was, what she was all about. How important is this for the state?
Well, in the sentencing proceedings, it is important. During a trial, what is important is whether or somebody has committed a crime, not the victim's family or the personal circumstances of an accused. That is all relevant to where we are now. So I think for the court to get a better insight into who Reeva was, how her family have grieved, the loss that they've suffered financially as well as emotionally, it's important to hear from a member of the family. Initially I thought they would be calling, closer family members, the mother, the father, uncle. They've decided not to testify. So this just gives the court an idea of another aspect. In other words, the interest of society, who the victim was. And that is something the court must look at. So it's got to look at all these factors. That's why sentencing is so difficult. It's probably the most difficult part of a criminal case. The court's got to, can you imagine having to weigh this up? 1 minute you say, Oscar must go to jail. The next you think about and say, no, well, he shouldn't go to jail. Give him a heavy sentence like community service, house arrest, treatment programs, compensation payment, all of that stuff. So, it's difficult. It's not one of those cases where the only sentence is going to be direct imprisonment. I mean, if this was an armed robbery or a instance of murder, premeditated murder, well, you're not looking at correctional supervision as an option. But because it's culpable homicide, the court has a wider spread of types of sentences it can impose. So it makes it even more difficult. So at the end of the day, we've got all these people in all of the countries in the world saying, send him to jail, some saying, don't send him to jail. You've got to have a balanced sentence. But correctional supervision is quite a heavy sentence on its own.
Actually, I want to recap on that. The fact that this trial was televised, a lot of people have gained interest in the law, in the way that the courts work. But what are we likely to see here in terms of the sentence?
Well, just to start about everybody becoming interested. It's good that the public know what happens in court. Many don't. They might read about it in the newspaper, but, in general, they don't know what a witness has to go through, the traumas of an accused, the traumas of a victim or a complainant in a case. They don't know. So now they do know. It's been criticized that maybe it was publicized too much. It was too much of a media circus. But I think it's setting a tone for what is going to happen in the future with cases. You're going to have more of this taking place, and I believe it's a good thing because the public are now fully aware. More people are running out and want to be lawyers, or more people want to be prosecutors, and more people say, well, let's go to court because I now know what's going to happen in court. But where are we going to go from now onwards? Well, they'll be, I think, tying up the evidence in aggravation by the state. There'll be argument by the defense and the state. And then the judge must give a ruling. I don't believe it's going to happen on Friday. I'll be very surprised if she gives a ruling and hands down her sentence on Friday, because I think she needs to consider it all and maybe a week or two down the line. But then I've heard today, listening to the news, that, she's not available next week. So I'm not quite sure what that means. But I really do think, because it's such a difficult part of the whole court process, that she needs to just show everybody that she's seriously considering all of these options, thinking about it, because she couldn't have considered it before Monday, really. I mean, she might have, thought about it, but not consider it from a legal perspective, because she wouldn't have had all the evidence that she now has, or that she will have by the close of argument from the state and from the defense.
More stories coming up after the break. Stay with us.